The objectives of this module are to define what intellectual property is and list the different types of intellectual property, define what a patent is and what its purpose is, define a trade secret and what its purpose is, define your intellectual property rights as a student at CSM, and lay out the process for pursuing patent protection. Intellectual property, often simply called IP, is property that lacks physical existence. When you own a car, having the car's title in your name makes that vehicle your property and gives you a legal right to use it, sell it, or modify it. Owning intellectual property is similar, only for mental creations, both artistic and functional. When you own intellectual property, you have a legally recognized monopoly over those particular intangible creations. There are four main types of intellectual property. You've probably heard many of them in one context or another. A patent protects functional inventions or ornamental, non-functional designs, depending on the type, and lasts between 14 and 20 years. Copyrights protect original works of art, such as books, images, music, and film, for the life of the author plus 70 years. Interestingly, and importantly, computer programs or code are actually copyright protected, like the text in a book, rather than patented. Trade secrets are an often underappreciated form of intellectual property. Formulas, methods, devices, or compilations of information can be protected as a trade secret for indefinite amounts of time. Coca-Cola's formula is one famous example of a trade secret. Finally, trademarks protect words, symbols, logos, designs, or slogans that identify and distinguish products or services. A trademark's good until a business ceases to use it. Regardless of the type, intellectual property is really important. It was seen as so important by the Founding Fathers that patents and copyrights are founded in Article 1 of the Constitution. Trademarks came in as part of the Commerce Clause to help ensure products could be traced back to their source. While there are many open source movements afoot that challenge the value of intellectual property protection, I'd ask you to think about it. How might IP promote the progress of science and the useful arts? Enter your thoughts in the quiz box before moving on to learn more about patents. As mentioned before, patents protect non-tangible property. A patent gives the holder the right to exclude others from making, using, selling, offering for sale, or importing a claimed invention. A patent is the government giving an individual, or individuals, a monopoly on a specific claimed invention for a limited term. Why would they do that, you might ask? Well, it isn't free. In order to get the monopoly, you have to fully disclose the invention in enough detail that another person, skilled in the art, could understand and replicate it. You have to share what you're doing with everyone, and that can be a steep trade-off, as we'll discuss later. There are three types of patents: plant patents, utility patents, and design patents. Let's assume you aren't developing any new plants as part of senior design, and talk about utility and design patents. I think it's a safe assumption. Utility patents are the type most engineers think of first. They protect inventions for 20 years from the date of filing of the full patent. Design patents protect ornamental, non-functional designs for a period of 14 years. Apple famously sued Samsung over the round corners and shape of one of their iPhone competitors using a design patent. Note two common misconceptions about patents. First, there are several things that can't be patented, like laws of nature, physical phenomenon, abstract ideas, and things that are protected by other means, such as literary, dramatic, musical, or artistic works. Second, patents are valid only in the territory that granted them. Therefore, a U.S. patent is only valid in the United States and will not be recognized in Brazil. There's no such thing as a true worldwide patent, and therefore companies operating in multiple countries must file to protect their ideas in every jurisdiction, which can get complicated and costly. So why get a patent, you might ask? Let's face it, having your name on a patent is sort of exciting, and it looks good on a resume. And while the cool factor by itself is a poor reason to pursue a patent, having a monopoly on specific intellectual property is extremely useful in gaining entry to or keeping others out of a crowded, fast-moving market. Moreover, you can create revenue by selling or licensing the rights to use patented IP, just like you can sell or license any other form of property. Like any other property, the value of a patent is dependent on the state of the property. So a patent that protects an unproven method has little value, whereas a patent for a method that has been tested and validated is much more valuable. If you walk down the aisle of many stores, you'll see patented or patent pending labels on many products where the patent itself is used as a marketing tool to promote unique aspects of a product. And finally, because patents are a form of property, valuable patents can be used to help obtain business funding. But there are downsides to pursuing a patent too. Patents are expensive. Average patent costs at the time of this recording are around $14,000. While that number can be lower for very simple patents and higher for very complex patents, it's a decent ballpark number. So if the intellectual property you hope to protect with a patent doesn't have any possibility of creating revenue equal to or greater than the cost of patenting the IP, you may want to reconsider pursuing a patent. In the end, patents are truly a business decision. A few other things to keep in mind when considering patents. Once you file a patent, you have disclosed your secret. Some intellectual property is best protected with a trade secret rather than a patent, and there's no going back after a patent application is in. We'll discuss trade secrets shortly. Your patent is only as good as your desire and ability to enforce that patent if someone infringes upon it. If you aren't willing to go to court to protect your rights, then you probably don't want to file a patent. In fact, if your only reason for patenting is to make sure no one else patents the idea, then public disclosure of the invention will serve that purpose for free. And finally, the right to exclude others does not necessarily mean that you can make, use, or sell what you've patented. That last point's a bit sticky, so let's look at an example. So why might someone who holds a patent not be able to make, use, or sell the patented invention, you ask? Well, it's possible that by making his or her patent good, a patentee could break the law. There's no rule that says a patented method has to be legal. For example, you could patent an improved method for human trafficking, drug making, or other illegal activity. We'll assume you're not going to do that. So the other reason that a patentee might not be able to use their own patent is that it might infringe a patent owned by another patentee. Let's look at a case of Company X and Company Y. Company X holds the patent on a foldable knife and manufactures a simple single-blade pocket knife. Company Y is new to the market and patents a multi-purpose foldable knife. Both hold valid patents. But if Company Y begins producing their multi-purpose foldable knife, they will be infringing on Company X's patent. So, holding the patent is important in that it keeps Company X from copying Company Y's invention. But it doesn't remove Company X's monopoly on foldable knives. As an engineer, situations like this can be truly frustrating. So what should Company Y do? Well, there are several options. One angle is to attempt to invalidate the patent held by Company X. This is often costly and time-consuming. However, a quick look at the technology page of the news will show you that it is often pursued. Can you make a case that the patented idea is obvious, or that the list of inventors is invalid? Can you find other holes in the patent? Most of the time, cooperation is preferable to litigation. So can you cross-license the IP of Company X? This is extremely common, and technology companies often have many cross-licensing agreements in place with outside partners that allow them to produce their products. It may be possible to find alternative technical solutions by using old technology. If you search expired patents, those ideas are up for grabs, and sometimes quite helpful in solving a problem. Note, this is one of the reasons the patent system was set up, so that there would be an open database of technologies. And finally, can you work with your colleagues in legal to engineer around the claims of Company X's patent? Sometimes this approach can actually force you to come up with new, innovative solutions that lead to even more valuable IP. So while it might be frustrating that Company X has this patent, it does help protect the company's business and employees, correct? And if Company Y pursues any of the last three options for avoiding patent infringement, doesn't it end up being a net positive? Interestingly, patents can be seen as a way to drive partnership and innovation rather than a hiccup in the innovation process. It all depends on how you approach things. Before we move on, let's check your knowledge of the topics we've covered so far. Great. It was mentioned earlier that patents aren't always the best option. Trade secrets are another way to protect intellectual property. Most companies employ some combined strategy of patents, trade secrets, and open source agreements in their business. So let's discuss trade secrets. Quite simply, trade secrets are secret information of commercial value. To qualify as intellectual property, a company or individual must make reasonable efforts to maintain the secrecy of the information. The wonderful things about trade secrets are, first, it's good until you disclose it. So if no one else figures it out and you don't share it, then you can keep a trade secret indefinitely. To put this in perspective, if Coca-Cola had patented its recipe when it was invented, the patent would have long since expired, and anyone could be making Coca-Cola with the original recipe. Instead, the company has maintained the recipe as a trade secret to this day. Miller Coors treats their yeast strain similarly, and many companies treat parts of their manufacturing process as a trade secret. Secondly, trade secrets are free. Moreover, if your invention is something that won't be publicly disclosed anyway, then paying for a monopoly on your idea may be a poor business decision. Trade secrets only work if others won't figure out your solution on their own. The Uniform Trade Secret Act, UTSA, protects companies and individuals from industrial espionage and other improper means that competitors might try to gain access to your secrets. However, there's no protection offered if another person or company genuinely develops the same idea. This is a major difference from a patent. One quick note on the idea that trade secrets must be protected by reasonable means. If you've had an internship and noticed language like that shown on internal communications, you have seen firsthand a company doing the bare minimum nod at reasonable means. Many companies have more stringent requirements and even check-in, check-out restrictions on proprietary information. When you go to work for your first company, make sure you know and follow their policies on protection of proprietary information, some of which may be considered a trade secret by the company. You may be wondering why we haven't covered the open source movement yet. It is a popular and growing movement that started in the software world and is transitioning to the hardware realm. Open source software developers released their code to the public and gave anyone access to use their creation, in effect foregoing their copyright. There are many frameworks for this. If you're curious, just try looking up Share Left Open Source License on Google and check out just one form of open source licensing agreement. In recent years, several companies have attempted to do the same thing with hardware. The challenge with hardware is that public disclosure of an invention in the hardware world has different implications since it falls under patent law. In short, while this is an exciting development in the IP world, few if any of the open source agreements have ever been tested in the courts. For this reason, the attorneys that were contacted while developing this module could not comment on best practices. We don't want to either encourage or discourage open source licensing, but you should be cautious and thoughtful of the untested nature of these agreements before proceeding, particularly when wading into the open source hardware world. There's a lot of possibility here for the future though. When it comes to your rights as a student, as an undergraduate student at the Colorado School of Mines, any intellectual property that you create belongs to you, unless you explicitly sign an agreement with a company or research group assigning IP to them. Note, use of campus facilities like the computer lab or design lab does not change that. You're paying tuition to have access to those facilities. Colorado School of Mines owns the rights to IP created by graduate students and faculty because they're under contract to the school in a way you as an undergraduate student are not. In senior design, we do our best to bring in the majority of the projects that do not require any intellectual property or non-disclosure agreements. However, some projects will require that you sign an intellectual property or non-disclosure agreement in order to work on the project. These projects are clearly marked with the initials IP, NDA, or IP plus NDA in the project title on the list of projects. The IP and NDA agreements for those projects are available for your review on the course Blackboard site under the Teaming Event section. Do not apply to any project with an IP or NDA designation in the title unless you're willing to agree to the agreement posted on Blackboard. Alright, let's check and make sure you're still paying attention. Okay, so now you know the basics of intellectual property, and you know your rights as a student at the Colorado School of Mines. But what happens when you have an idea that you want to patent? The first question is when you should patent, and the answer to that is as soon as possible. In the United States, patents are awarded on a first-to-file basis. That means that it doesn't really matter who had the idea first, it just matters that they filed the patent application before anyone else. For this reason, it's a best practice to file before any use, sale, or disclosure of an idea to any third party. In fact, in many other countries, any public disclosure before filing the patent may remove your ability to file for a patent altogether. In the United States, one commonly used tool to help protect an idea early is a provisional patent. A provisional patent costs much less than a full patent application, typically between $1,000 and $3,000, and allows an inventor to lock in an application date quickly before they're ready to submit a full application. Filing a provisional patent gives the inventor 1 year to prepare a full patent application. When the full application is submitted, it is treated as if it was filed on the date of the submission of the provisional filing. If an inventor fails to file the full patent application within the 1 year window, then they lose the right to maintain that submission date. So, in summary, once you've decided you'd like to patent your idea, move quickly and consider filing a provisional patent. The typical process for filing a patent goes something like this. First, prepare and submit an invention disclosure. There's a template for this on Blackboard under Resources. As part of this invention disclosure, you'll be asked to do a basic patent search and really try and clarify what it is you think is unique and patentable. Next, file a provisional patent based on the invention disclosure you created. You can work with either your client, the school, or an outside company if you own the IP. After you file the provisional patent, and over the coming year, you'll refine your design, complete a detailed search of prior art, and prepare a full patent application to be submitted. This usually involves lots of back and forth with a law firm. And then, once the application is in, you'll need to wait. Patent applications can take a long time to work through the system, many years in fact. But because you were first to file, you can go ahead and market your product as patent pending during that time. We hope this module on intellectual property has been helpful. Congratulations and good luck on your senior design project.